ये mic. Okay. So, just to avoid any litigation if it is there, it possible litigation which can come up in future, and understanding the work of other researchers, that is essentially important. When we can, while doing the research, we can think that we can make certain improvisations, we can make certain changes into that particular invention. So, in that particular scenario that is required. So, why we do it? We do it just to check out what is the new idea or what is the alternative technologies which could be available in that area, or for guiding the management of R&D in terms of businesses. Then like same for the research, avoiding reinventing the wheel, redoing the same thing again to avoid wastage of resources and efforts. Okay, and identifying the key players. Key players makes sense जब आपका कोई for example some agricultural instrument is there. Okay, so then we are looking for whether similar type of invention is known by the certain players who are into the market. What type of invention is people are making for a harvester is there, for example a cumin harvester is there. So, what type of harvesters are already there in the market, what problems those harvesters are having, how we can improvise that technology. So, that type of a thing. So, what is considered as prior art? Anything which is a published document, anything which is traditional known, like neem ka knowledge hai. Neem ka knowledge is a traditionally known language, knowledge. Okay. What is not considered as a prior art is which is a trade secret, जो कुछ ही लोगों को पता है, which is going from mouth to mouth. आपका कोई internal circulation के documents है, आपने जो है lab notebook बनाया, that is used for internal circulation, so that is not considered as a prior art. Or any information which has not been publicly disclosed. Now, how it is termed prior uses? Anywhere it has been used earlier, that could be आपने for example trade shows में दिखाया हो, किसी public forum पे you have shown that invention, that is also considered as a prior art. Or any oral presentation which for example like I was saying abstract presentation in any of the conferences, that would also be considered as a prior art. So, if any time you feel that your invention could make a patentable thing, so avoid publishing or presenting that information in terms of any public forums. So, what type of patent searches are available is, this could be your patentability search, like we are doing for whether it is patentable or not. FTOs or the market opinion searches, when that invention is not patentable per se, but then we can introduce that invention into the market. Okay, so from the market perspective that can be done. Patent validity search for to check the validity, किसी और के patent की तो नहीं उसको infringe कर रहा है, so all that thing. So, how we do a patent search? Like I will show you how that invention looks like. This is how a patent disclosure looks like. Okay. So, in this disclosure there is on the top, this is a US patent. On the top it shows the filing country name, then there is the name of the invention, then the name of the inventors, like in the manuscripts we check na, title, keywords, inventors, publisher uska author's ka name, then all those things we are using in terms of manuscript. So, same here we can search by the name of the invention, the inventors, the company name in case it is an invention which is your, for example like I said agricultural machinery is there. So, Mahindra ka machinery hai ya Deere and Deere ka machinery hai. So, which all those technology partners are there in that particular scenario. Then if we are looking for a particular time period, so time based search is also available. Then description of the invention में any keywords which we feel that could be there in the invention, on the basis of that also we can do a search. So, this is how the basic patent search strategy is, to broadly start with what overall could be there and then narrowing down onto the specific points, then carefully managing the documents. Carefully managing documents is just checking through specific points in terms of all the fields. Okay. Then keywords expressing the essential concept of invention. Like if it is a harvester, तो आपका harvester में कितना उसके अंदर what is the speed of it is working, or a specific type of machinery which could be used for it, processing का method जो होगा, how it is working. So all those points. कोई method of for example it's a chemical process, so उस chemical process में if it is the composition which is there, then that composition at particular RPM it is working, incubation timings are there, then what particular incubation timings are there. So those specific points with respect to the type of invention we are working, that could be a biotechnology invention, that could be a engineering के devices, any type of the invention, the particular keywords in that process or that device or that composition, that is we are supposed to check. Then synonyms of keywords. Synonyms of keywords is device, article, or system. So that type of a thing can be there. Pen के लिए a writing instrument. Okay. Chair के लिए something on which person can sit. So there are a number of ways people write all those things. For a formulation it could be a composition. So that type of a thing. So then we have to look for the synonyms also. Then like I said, the components is title, inventor, application number, then date of application, what is the patent number, and then what is the classification. Classification in terms of animal patent, human आपका intervention है, plant है. So there is a different criteria and classification per se for that. So how we do a patent search? Now the patent search is essentially done by the text search, which is actually based on the keyword search. The keywords which I said, like something which are the main points in the invention. It's a green process, then the green process, आप उसमें कोई organic reagent नहीं है, then what all could be there. Neem based product है, तो उसमें neem से आप plant part कौन सा है. So all these things can be there in terms of your keyword search. Then classification, international patent classification, number search in terms of patent number, application number, publication number. Then structural search in terms of chemical patents. So chemistry based में उसमें आपका Marcus claims बनता है. Then what is the structure, what is the formula for that. So all those things are there. And the sequence search in terms of genes or proteins. What is the specific gene sequence or the protein sequences there. So these are the websites which provide free access to the patent databases. Now there are a number of paid databases and there are a number of free databases also. For manuscripts they essentially go for PubMed, that is giving a good amount of information. For patents there are a number of databases which are available. So these are the free ones. The Google patent for doing a worldwide search. IP India is for the Indian Patent Office, on which it is having the information from the patent which has been granted since 1912, and it comprises the full information. आपका complete filing है, all the original documentation. So every information with respect to what has been there in the patent e-register, that we can find from the Indian Patent Office website. Then is your uspto.gov. USPTO is for US patents. So whatever US patents are there, that information since 1976, that can be found on this website. So this database is having information for the US patents. Then worldwide is eSpaceNet. eSpaceNet is European patent data collection. It is having information for European, Japanese abstracts, and basically EPO का सारा data is available on the eSpaceNet. Essentially all the databases, वो चाहे आपका Google patent हो, USPTO हो, eSpaceNet हो, they are giving the information about the patents. एक database will not give you the total information. Okay. If we are looking for a specific patent in a specific jurisdiction, so then essentially we go for that. Like WIPO के लिए, if we are specifically looking for the your PCT applications, then we can check for the PCT based applications only. So that type of these databases are there. Now this is the patent classification, like I was saying. for human necessities, for performing operations, chemistry ka different is there, textiles is there. So, okay, on the okay, in this it is not, we cannot see the class here, but generally usi mein na niche they have written the class also, in that what particular class is there. So, class search is also there. So, this is a screenshot of the Indian Patent Office website, which is showing the information with regard to the Indian patent applications. So, there is this you can just add in the information with respect to the abstract, your complete specification, application number, inventor's name, all that information is there. But specific field search can be there to be more precise and be more accurate. So, it is not like on PubMed we are just writing the information in the one field which is there, but if we narrow down it, so maybe specific field search can be there. So, that is how it is there. So, for example, here we have given device or apparatus or equipment. So, this is what we were saying, a synonym based search. So, synonyms also has to be checked. Ab sirf device there, and then the options which are there, it could be in the form of a component, it could be in the form of a equipment. So, synonyms has to be checked into. So, if we are giving an agricultural based title is there, then a device. So, on the basis a number of search options it has given. From that we can just go through it and then we can search what specific could be there with respect to our invention. This is Google patent. Google patent पे we can get the information with respect to the patents as well as the non-patent literature also. क्योंकि manuscript is also considered as a prior art for the inventions. Now, this is for eSpaceNet. eSpaceNet also gives you a advanced search way. It is giving you the option of the different types of fields which are there for title, for your abstract, for publication number, application number if it is there. We know the specific application number. We know the time frame in which we want to do a search. कि पिछले 2 साल में कोई भी invention publish हुआ. So then we can give a time frame for that. So then it can search accordingly for those time periods only. This is USPTO. USPTO is not a very user friendly, it doesn't have a very user friendly interface, but then for the US patent it actually gives all the information. So, here also though fields are there, but it is more easy to look for those fields in your eSpaceNet or InPass ka website par. So, then we can just have hands on for these exercises. If you are having access to the net, then we can just have it, we can do it, or you have the access to net, no? So, then we can have it. ले रही हूँ ना, फ़ोन से लगाती हूँ इसमें, लेगी। I'll show you. It's ipindia.gov.in. Have you come up to this web page? ipindia.gov.in. You will get this web page. This is there. ठीक है, इस पर there is this option of public search is there. It is there. This public search. Reach this point. So this is the public search for patent. This is the public search for trademark, for the designs. Okay. So whatsoever you want to search on the website of Indian Patent Office, that we can go through from this single click. आपको patent search करना है, then to it is there trademark and then the designs. Okay, this so then first we'll check out. दोबारा इसी पे आके दिखा देते हैं. So this is the web page which I was showing. You have come on this web page. ठीक है. It is there na, public search patents at the top. That's there. Just going step by step so that in case you want to search for other IPs also, so you can search from the single page. ठीक है. So you have come to this page. Now it's there. Okay. So here I can just write the application number if I want to write. You can write 1575 dash. Can you just, it's visible to all, 1575 dash MUM.
You have to put this as the application number. Slash MUM, capital MUM, slash
2015.
This 2015 is the year when the patent application has been filed.
MUM in the jurisdiction. In Indian Patent Office there are 4 jurisdictions: East, West, North and South. So for the for all the north based patent application, Delhi is the jurisdiction, so it is Delhi. For your Gujarat, Mumbai and all that area, that is MUM, right. So then it is the captcha at the base. Reached? Done? Okay. So here it is showing when this application was made, the date is there, this is there, followed by the status that it has been a published application, like sir was saying in the morning, no, that after 18 months it will be published. Okay. Before that it is only the patent office knows that the patent application has been filed. It doesn't come in the public domain. Now anyone can just read through your application, whatever we have submitted on the website of the Indian Patent Office. So the status is published. Now we can check what is the application status. So this is how it will show. All the details for this application we can see it here. When the application was filed, when it has been examined, and then the date of grant. So it was granted in 2019. Okay. So this is how we can do a basic prior art search on the basis of the patent application number. Then similarly on this page, no, we can just go back, and here we can write the application number, or we can write the name of the inventors. For example, if you want to check whether there is application in the name of ICAR. Okay, so we have written, because in all the IARA applications, ICAR is the applicant. Inventors are the scientists, but applicant is ICAR. So this is all the application which are there in the name of ICAR. आपका वो IARA से भी हो सकता है और any of the ICAR institutes.
So as this page is showing you the application date. So this is the date exactly when the application has been filed with the Indian Patent Office. And then you can see the status also. The application status is showing published. So all these applications have been.
All three are applications are published. So all these three, this first one, the third one, and the seventh one, these are the IRA applications which had been filed in the past 3 months. Okay.
So usually it happens that after filing the application, only when the 18 months have been completed, then only the application gets published.
So this is from agricultural chemicals. So this is how the details come like. Okay. Like for this application, it is only showing, it is awaiting examination. So it has not been examined yet, means they have not checked whether it is a patentable invention or not, whatever the issues would have been there or not. So that would be checked at a later time point. Okay. So this is how we can just search for any of the application by name of the applicant. Any specific query if someone has, then we can search on that basis also. Anything you want to.
You are researchers, so you can think of the keywords from your research and can feed in and can do a search. Try it at your end.
Any specific query if someone has with respect to any of the inventions या कैसे search करना है?
कहीं पे if you are falling short of, then we are there to help you out.
Because a number of examples we can take, but then it will go the same way. So it is better if you have any specific examples, we can just do it that particular way, because that would be the live examples which you people have. जैसे उससे कैसे पता है? But then it is your
Applicant is ICAR, so we are able to track ICAR.
नहीं ICAR में see the point is like agricultural chemicals, that is one unit of address of the inventor, right? So it is not, it won't, it is, we can just see it on the web page that is available, but generally that information always is not there. From IARA, when we are filing, we are giving the complete address of the inventor goes, but then that is at times not there on the site. So on the paid databases,
This site is basically what it is doing is the information which we have given at the time of filing of the application. So we have given the information that the applicant is ICAR. So when we are putting in ICAR, we are getting all the applications of ICAR which have been filed. But the information, as in you are talking about a specific division of ICAR which have been given,
that field is not there.
that field is not being given. So you will not be able to get it like that. But definitely if you know that from ICAR, if you know the keywords of a particular invention you are looking for, those keywords you can feed in and then you can look up for the application. That can be. ये डॉक्यूमेंट्स नहीं बताते ना क्या था
इंजीनियरिंग का ले लेते ना टाइप. So here we can see all the documents which would have been uploaded when this patent application has been filed. Okay. So like this is the patent application, how it looks like.
So when we are submitting the patent application to the Indian Patent Office, this is how the application has been drafted. When we say that the application is under draft or we are drafting the application, this is the final draft, the application it is when it is filed. So it has claims into it, it has the description part into it, where we are describing all the parts of our invention. At the end there are claims, but exactly, claims is basically, those are the things on the basis of which you can later on ask for your rights, because they hold the rights of on your invention. So how your claims have been drafted, that is very important. A lawyer or an attorney who has given you a well drafted claim, then later on at the time of litigation, if you want to sue someone or if you want to tell someone that you are infringing our patent, those claims are the key players there. So this is how the whole invention being written down into an application format and sent to the Indian Patent Office.
कहाँ से आया?
लास्ट सेशन था उसमें मैंने एक क्वेश्चन पूछा था ना कि जो एक पर्टिकुलर जैसे मेथड है क्या उस पर पेटेंट हो सकता है, तो उन्होंने बोला था कि नहीं हो सकता है, बट आईसीआर से ये मेथड ऑफ प्रिपेयरिंग हाई प्योरिटी फाइकोसाइनिन एक्सट्रैक्ट, ये तो मेथड हुआ ना, इस पे तो पेटेंट फाइल कर रखा है इन्होंने.
It was not like that. It was not like that there cannot be any patent on the method. He was like that something the question over there was the composition, how to differentiate a particular compound on the basis of invention. How do you differentiate? It's not like that method cannot be patented. A method, the process, and he was like that the methods are usually a very basic method which we use, right? But it is if there is a very unique, a very different method, a very novel method, that can definitely be patented. In fact, in his later slides, he was talking about that a method can be patented. But then definitely you need to have a very different idea into it, a very unique inventive step to it. It should not be a very regular way of forming a method of extracting it. Right?
Like you were saying, the method of isolating azadirachtin from the neem. Okay. So if it is the basic process which people are using over a period of time, ठीक है, and a slight tweaking of RPM is there, slight tweaking of उसमें अगर alcohol आपका ethanol use हुआ and then you are using butanol, so that is a very, as per you that could be a difference in the process, but then that is a very obvious thing which can be changed. So that type of change in the method is not patentable. That means method is not patentable, but the composition per se उससे आप जो final बना रहे हो, that could be a patentable thing. So that is how it takes. Any other query with respect to how to search for the invention or any specific thing you want to search and you were not able to do it?
Have you guys tried this Nuance search mode?
अच्छा we should tell them एक्सीडेंट प्रोसेस हुआ था ना, इसमें कोई है मैसेज हमारा जल्दी हुआ, अभी मेरा कौन सा ग्रांट हुआ, पूछ देना कि कितनी जल्दी पब्लिश्ड और फिर करेक्ट रहती है.
वो लीगल स्टेटस भी नहीं बताया ना, अभी वो लीगल बताएंगे तो बताने का मतलब है
आपने बताया इतना.
हाँ नहीं वो कर सकता है एक एटसीआर की साइट पे हाउ टू पुट इन बुलियंस, मतलब हाउ टू सर्च
एटसीआर की साइट पे है हमारे पास कुछ.
Okay, these are all the public databases like which you will be easily able to have an access on. Now we'll be showing it on a paid database which we are using at our unit. So we'll be going to the site and then we'll be looking for some of the paid databases, how exactly a document looks like.
This is for your Google patent. Okay, here it is showing this information.
This is again a free database.
Wait a minute. Okay, so here it is showing the field search, like I was telling you, na, that specific terms, field with respect to the dates, with respect to the name of the inventor, assignee, which patent office you want to search for, any status. So on the basis of that we can do a advanced search. So this is for Google patent. Okay, like here it is giving that option of checking the patent office, different it is there, status, whether it has been a granted patent application or it is only a published one, whether it is in patent or design. So that ways. Hello, ma'am. Hello, ma'am. So this is how it's the interface for the paid databases. So here we can just search specific searches there. So here also we can just add in the name. For example, it with the last patent we are doing for the xanthophyll. So it's giving almost 4800 records, which is specifically for the xanthophyll based things only, or that type of lutein compositions. Then here you can do, you were saying, address and all that thing. So here that option of slight option is there, not much option is there, but then your name of the assignee or the numbers and that, whatever fields are there when we are giving that particular information. So that type of information is there. So any specific point if it is there, then we can just take it. Otherwise we can just add in different options and then we can do the search. It will go on like on the similar basis only, but for device it will go as in device ka jo bhi components rahega. For composition we can just add in the composition, for example xanthophyll, extraction, that type of a thing. Any query if you guys have? So if anything specific is there, we can just take that, or otherwise we can just wind up and then we can start with the next session. Any queries? So that was all with respect to this. Otherwise, so essentially it is like with one database also we don't get all the information per se. So we always advise just look out for different options, whatever is available. आप Indian Patent Office के website पे भी search करो, then check on Google Patents also, or if the paid databases are available, just check on that also. So that is how we can just search for whatever information is available with respect to the literature. That is all. Thank you. Any queries? आप व्हाट्सएप कर दीजिए जैसे कर दो.
So any interactions you understood how to do the ANR search? Number of products are
Yes, sir.
become
It has
max,
it has decreased.
Take one attendance.
That is what I was also thinking.
Take one attendance.
Should I call the name?
No, yeah, it's better to take the name. Okay. Any questions? Any clarifications? No.
Release करा था.
Okay. I think they have understood everything.
Yeah, that's what I told her.
We will move on to
Ma'am,
CMI
इसमें-
वाला है ना? Current CPC CMI.
जी जी जी
Copy मत कीजिए.
मैं इसी में से चला लूँ. All yours,
If no more questions for the previous session, and we will move on to the very important lecture this afternoon. This lecture is important from many perspectives. Number one is the speaker herself is practicing a patent professional or IPR professional representing our country patent office. That's number one. Number two, the content of this lecture would be very useful to all of you, would be very rewarding. We heard this lecture before also in the same auditorium, loaded with information. I'm sure that would make you clear about how a patenting system works in our country. So we have with us Dr. Usha Rao, Deputy Controller of Patents, working for Ministry of Commerce. Under this ministry, the IPR related regulations are being operated through 4 or 5 offices in our country, at least 4 offices in our country. Dr. Usha Rao would tell about those offices and what they are really doing. About Dr. Usha Rao, she is a PhD in biotechnology, joined Government of India this patent office as a patent examiner. Already more than 20 years of service, 20 years of experience in a different capacities. Handling the applications comes from the applicants like all of us, number one. Number two, scrutinizing them, hearing them, granting them, and in a typical hierarchical manner, she elevated to the level of deputy controller. So well experienced, and the information what she is going to share with us is directly coming from the patent office professional. So that's, it cannot be better than this. So with that, I call upon Dr. Usha Rao to come on to the dais and deliver the lecture. So now it is between you and the audience, and be interactive and try to get all your doubts clarified. Yeah, thank you, Usha Rao. Yeah. That mic is important because it is online, so you can connect this mic.
Oh, it's okay. I'll be here.
And
Not
put it
an
here.
issue.
Yeah. Okay.
Yeah, good afternoon everyone. I know it's a very difficult time now because after lunch I can recollect when I used to sit for lectures, and I used to feel really very sleepy after the lunch. So I know it's going to be a challenge for me to keep you all engaged. So let me keep it as interactive as possible. I want you all to reply, to respond, and to ask questions whenever you feel you are free to ask questions whenever you want. I do not think that you are not aware of intellectual property rights, because I think
since morning you have been bombarded with this material, but I will try to give a perspective as to why intellectual property and why intellectual property rights. So, as Dr. Kumar has said, and I really am thankful to him because last time I was here, I think just 21 days back, and it was very surprising that I was asked to come and deliver a lecture again. But thank you, sir. It's very nice because when we sit in our offices, we do not understand the perspective of the applicants, because you will all be applicants, right? And we need to understand the perspective of the applicant also, so that the patent office or the intellectual property office can actually, we can all work together for one cause, and that is the protection of IP or IPR of our country, right? So let's move forward. So we are normally conducting intellectual property awareness programs so that all stakeholders are aware of what are intellectual property and what is what are the associated rights to around it. And if you are aware, in 2016 the Government of India had launched the National IPR policy. Are you aware of this? No. Okay. So the Government of India launched the National IPR policy in 2016, and there were various pillars, 7 pillars in this National IPR policy, and which the National IPR policy paved the way to towards a system where the IPRs, the IP as well as the IPRs are protected. And the slogan for in this National IPR policy was very catchy and very different. It talked about a creative India and an innovative India. So not only are we looking at innovations or inventions, we are also looking at the creative aspect. So we understand that every country has a lot of creativity, and India in itself is very creative since the past so many generations. So to capture and to see to it that all these are protected, all these are a part of the IPR ecosystem, this particular slogan was coined. Now let's look at the basic point. So the first thing that comes to your mind is an idea, right? So even now when you're sitting, you must be thinking of something, must be moving in your brain, right? So let's look at it. Suppose you are a singer, you must be singing some song. If you are a writer, you must be thinking of some idea of a story, right? And because we are all scientists, I'm sure if you are having some experiment which is running in your lab, then you must be thinking of ways and means to make that experiment successful, right? So those are all ideas, and because we have intellect, right? So this is called intellectual, okay? But the basic point is, an idea, can it be protected? Yes, what is your thought on that? Anyone? Yes, can it be protected? No, right? Why? Yes, because an idea is just a germ, right? It is just the seed. But that seed has to be germinated. And how is it germinated? By writing. It has to be expressed in a certain form of writing. And I have given these, like if it is a literary, it can be expressed as a literary, musical or dramatic aspect, or it can be in the form of a logo, mark, device, aesthetic look of the product, applied to a product or process, or expressed in any other form. But it has to be there in writing. Only then it can be protected, right? But why protection? What is the whole meaning of protection. Why protection? So the first, I have just mentioned it in this slide. When you look at property, it can be divided into two aspects as I have shown, tangible and intangible. So tangible is your pen, your car, your house, anything which you can feel, touch, see and use, right? So all that are become tangible, which are measurable, and that you have to protect that, right? How do you protect your house or how do you protect your car? Can you protect it? Yes. How? हाँ, उसके पहले आप क्या करते हो? Yes, you have to register it, right? Where do you register it? In the RTO, right? So what are you doing actually? You are taking a right, right? A legal right over that particular car or whatever. Suppose it's a house, then over your house, or it's a car, right? So what are you doing? You are establishing a legal right over that particular property. And if suppose by chance something happens, then you can claim, right? Then you go for an insurance and then you can claim that okay, this is my property and I have to because something has happened to it, because there is a theft or there is something wrong that has happened, so now I can claim damages, right? है ना? That is what happens. That is for our normal property. But what happens to intellectual property? You cannot see it. Suppose you write a music. Suppose you write some score of a song, or you write a story. Till you establish your right over it, you will not be able to claim for any sort of damages if someone copies it. So I'm sure you must have heard about all this. In plagiarism is a very important part, right? Also, you must have seen that there are a lot of all this happens a lot in, especially in the music industry or in the film industry, because people say that X has stolen my story, right? So how is that going to be settled in the court of law? It is only when it is established that you have a legal right over it. Okay, so that is where intellectual property right comes into play. So you have to see to it that whatever intellectual property you are creating by way of idea, by way of invention, by way of any sort of creative activity, that should be protected in your name, right? So as I have, you can see, so intellectual property is intangible and it cannot be measured, right? Because when you buy a house, you pay a certain amount and you buy that house, so it is measured. You can see it, you know that your house is say of 1000 square feet, but an idea or intellectual property cannot be measured, so in that way it is intangible. And intellectual property rights can be protected under industrial property and copyrights. And under the industrial property you have IPR rights such as patents, designs, semiconductor integrated layout designs, trademarks and GIs. And under the copyrights you of course have the copyright. So why this intellectual property regime? Why is it so important? Okay, because it, first of all, it gives the inventor or the creator, the government gives a right to the inventor or creator to reap the benefit. Okay, so you are working in a lab day in and day out, you are using the resources of the laboratory or of the institute, and if you are able to create or to create a product or a process and you are able to get it granted, right? So you have a monopoly right over your creation or over your invention, and you have the right to use it as an economic tool. So you can, what you can do is, you can either license it, you can either sell it, or you can use it as a, you can take a lease. You can lease it out and you can take money out of it. So all these are aspects where the patentee or the invention or inventor or the creator gets a monopoly over his right, right? So it encourages creativity and innovation by granting rights to the individuals who risk their time and money in creative endeavors. So what are the benefits of IP protection? So I have listed the benefits. So let's look at them. So when you look at economy, right? So intellectual property rights are economic tools, as I have just mentioned, and they contribute to the economy of that particular country. So you should understand that when we talk about intellectual property rights, although it may be a personal intellectual property right, but at the end of the day, it is the intellectual property of the country, because somewhere or the other you are contributing towards the, or your invention or your creation is contributing towards the economy of the country. So how? Let us look at it. So first let us look at a negative thing. So let's say, what is the software that is used in laptops? I mean, without that, a laptop is just a without the software, what is a laptop? What is the value of the laptop? Nothing, right? So what is the software that we use? Yes? Yes. So Windows, which company does it belong to? Microsoft, right? And Microsoft is a company from which country? US. So just imagine, all of you, if you have laptops, all of you, your 15 number, all of you have laptops, okay? Leave alone the cost of the laptop. If you look just at the cost of the software, you are paying something around 8,000 rupees for the Windows software. So how much are you spending? 50 into 8,000. My maths is not very good. I hope your maths is better than mine. How much? 4 lakhs. Bas 4 lakhs. Yes. 8,000 into 40? 50. Yeah, 4 lakhs. So 4 lakhs, just imagine 4 lakhs you are giving, contributing to what? To where? Where is all this money going to? Right? So what are we doing? We are exporting dollars. Right? So what is the thing? What is the solution for this? Yes? You have to reply, you have to respond. If not, I am not going to be able to get on with this. Yes, you have to develop your, India should develop its own software, right? So we are looking at that, at that level, that we want that innovation should come, or innovation or creativity should come from the youth itself in such a way that we are able to contribute towards our economy. Because what are we doing now? We are exporting dollars, we are contributing to the economy of other countries. So I have just given you one example. There are so many other examples where we are using inventions or creations of different countries. So we should try to develop our own system so that we contribute towards our own economy. Let's look at it from a positive way. Which is the movie which is very famous nowadays? Yes, Kalki, right? So Kalki is a movie where how much crores has it earned on an average, if you can just. Yes? You don't watch movies? Yeah, more than 1,000 crores. Huh? And just imagine, it is a movie which is made in India, right? Who is the producer? Director? Yeah. So it's an Indian based movie, right? It's a made in India movie. So just imagine the amount of dollars that has been imported into the country, right? Because this movie is not only famous in India, but it is also famous in other foreign jurisdictions. So wherever the movie was seen or watched, the amount of dollars, a lot of dollars have flown into India, right? So that is the value of that IP, the creativity, and no one can copy that movie, right? Why? Because it has a IPR attached to it. What is it? Copyright, right? So no one can. So what does it mean? The IPR has such a lot of value. That is what I'm trying to tell you. So you have to look at it from that angle. Not only we are scientists and we only think about science, but yes, there is a lot of other aspects which need to be looked into, because now maybe you are in your post graduation, right? All of you are postgraduates, but later on when you go into the into the field, then you should be able to know what is IPR and how it can contribute towards the towards the IPR ecosystem of the country. When you look at innovation, we are aware of the COVID vaccines, right? So that is a very good example of innovation. How within a very short span of time, say within 1 year, vaccines were available to the public, because of which a lot of us were saved from COVID, effects of COVID. Now, are you aware of what are the different vaccines that were available? Covishield and? Covishield was what? AstraZeneca and Serum Institute, while Covaxin was purely Indian. So just think about it, that you are using the IP of someone, some innovator, some creator, right? Okay, and it benefits the consumers and society. So I've just given examples how IP and IPRs benefit the consumers, and companies that use IPR are generally found to be more successful. So let's look at intellectual property rights. So they are patents, designs, trademarks, geographical indications, copyrights, and SICLDR. Can you tell me some other IPRs which are associated with your subject matter? So there is something called plant variety, right? Are you aware of that? Yes. So a plant cannot be granted a patent, but it can be protected under the Plants Variety Act, which is governed by the Ministry of Agriculture. Okay, we do not take care of the plant aspect, because we deal with the industrial aspect of intellectual property rights. So our office, the Office of the Controller General of Patents, Designs and Trademark, it caters to the 6 IPRs that I have just talked about. And this is our website, www.ipindia.gov.in, and you can see that we have everything listed out on our website. And if you go here, you can do the search, as I think you had just mentioned, that you need to understand that intellectual property rights are territorial rights. So if you want to file for a patent if you want to protect your invention in a particular country, you have to file for a patent in that particular country. So it is a territorial right. So whatever patent has been filed, whether it has been granted or refused, all of that is available on our website. So whatever patent has been filed, granted, refused in India, everything is available on our website. So if you are doing any sort of project, suppose you start a new project, please be sure to go to our website and do a small check, so that whatever you do not repeat whatever has already been done, whatever has already been granted. because if you do that, it's a waste of resources, it's a waste of money. Please do not reinvent the wheel. Just do a small short search, small search. You will find out whether it has been granted in India or not. Okay. So we also have comprehensive e-filing. So if you want to file any application which is related to IPR, you can file it online. You do not need to come to the office to file your application. So just a small example of IP in everyday life. So you can see a very simple instrument that we use, a pen, has these many different types of IPRs associated with it. Right, so you can see this is still a very quite an old slide, so I think the number of patents would have gone up. But you can get a patent for so many aspects of your pen, right? And the name can be protected by trademark. The design can be protected by the design registration, and you can have the patent for the pen, for the body, for everything, for the ink, everything. So let's look at patents. So you can see the evolution of telephone here. So I'm sure you may not have seen it, but I think till the 1990s, you must be born sometime in the 1990s. So till then, I'm sure you would not have been able, you would not have seen all these. But this is how telephone has evolved through the years, right? And at every stage, there has been a problem because of which people have come up with a solution. So the patent, if you look at it, is actually a problem solution aspect. So you know that you have a problem, and if you have a scientific response to it, a scientific solution to it, then you can come up with a subject matter which can be patentable. Famous inventors and inventions. So Aryabhatta has been given the number 0 was invented by him, without which today the computers would not be could not be made. Sir C.V. Raman won the Nobel Prize for the Raman effect. And of course, Dr. APJ Abdul Kalam was known for his crucial role in the development of India's missile and nuclear weapons program. And we are a very proud country where we could manage to, yes, land on the, yes, right, land on the south pole of the moon. World famous chip and most widely used in computers, that is the Intel Pentium chip, was invented by Mr. Vinod Tham, and he was called the father of the Pentium chip. I'm sure you are able to you know about all these. These are the most simple inventions that were studied by us during our classes, 10th and 12th. So the first patent that was granted in India was in 1856, and which was an efficient pankha pulling machine. So this was because we were under the British rule, and they had come up with something called privileges. Okay, and under this, after this, we kept on improving on our Patents Act, and based on the society. What is required, I mean the societal development. Another famous patent, are you aware of this? So Michael Jackson, he used to dance in such a way that it used to be called the yes, what was this called? Anti-gravity illusion. So this was, just imagine, he was a dancer, but he developed this shoe so that he would not fall off the stage, or he could create this illusion in such a way that it would always be successful. right? So that is what I said, a problem and a solution. And this was granted a patent in USPTO. Some other famous inventions, the nano car, the hepatitis vaccine, Jaipur foot. So what is a patent? A patent is a grant by the state or the sovereign to a person, giving exclusive right to stop others from making, using, exercising, vending and importing your particular invention. This is for a limited time period. For patents it is 20 years, right? So it is governed by the Patents Act 1970 and the Patents Rule 2003. And whenever we go to institutes where research is taking place, we always try to in fact force them, or I should not say force them, but we try to tell them that you have to first file for a patent application, only then after that you publish your results in the publications, because once you publish it, it becomes open to the public. And once it becomes open to the public, if you file for a patent application, then it will not be easy for the patent office to file for to grant the patent, because it is open to, now it is a disclosure, it is there as the prior art, because as you are aware, in patent the date of filing is very important. Okay. So what is the criteria of patentability? It should be new, novelty, inventive step. It should not be it should not be obvious to a person skilled in the art, and it should be capable of industrial application. It should not fall within the provisions of Section 3 and Section 4 of the Patents Act. So under this there are different subject matters that are listed, where method of treatment is not allowed, process where yeah, I know it's very, everyone is feeling very sleepy, half of them are sleeping. Process is not sorry, plants are not allowed to be patented. So there are different subject matter which is listed there. So this is the list. I will not go so method of agriculture or horticulture is not patentable. So what is the if you want to file for a patent application, you need to understand that a patent application is a techno-legal document. So you need to provide two aspects. One is the legal aspect, where you talk about your name, the name of the applicant, the name of the inventors. Because suppose, for example, if you are a inventor, right, you have developed a particular product. Okay, now IRI or Dr. Kumar would want to file for a patent application, right? So Dr. Kumar, who's your research investigator, principal scientist, and some of the scientists who have worked in that project, you will all be called the inventors, right? IRI would be the applicant. Okay, so the inventors have to give a right to the applicant to file on their behalf. Now the applicant, the patent is granted to the applicant, but there can be a contract between the applicant as well as the inventors, where royalty can be given to the inventors, right? There are examples where in CSIR a product has been an invention has been filed, it has been granted, and then it was licensed to a company, and because of that they got a lot of revenue, right? And CSIR gave a royalty share to all the inventors, right? So that is how it works, and that is how it can be a very good economic tool, because whatever money comes into the system, or it comes to the institute, can be again put back, so that new products are developed, new aspects are can be looked into. Okay. So all these have to be given, like for example, and then once you give your legal aspects, then you have to also give your technical specification. Now this technical specification is almost similar to what you gave when you have to write for a paper, when you write a paper for your publication. It is almost similar, except that it needs to be a little bit more elaborated, and also there is a particular aspect which is to be read, that is called the claims. Now these claims define the boundary of your invention. So yes, there is a little bit of technical legality involved, but there are a lot of institutes, government institutes, which can help you in writing, in drafting your application. So please do not bother about that aspect. If you are able to come up with a product or a process which is going to be beneficial, then you can always go for a patent. Okay. So these are the fees that you have to file. And this is the application procedure. I will not go into this, but basically the fact is that once it is filed in the patent office, then it is examined. When I had joined, I joined as an examiner in the field of biopharmaceuticals, and we check the application whether it is properly drafted, whether all the data is properly provided, and we do a search, as you had just learned in the previous session. So we do a search to find if there is any document which is going to be, which is going to kill the novelty, or which is not in, because of which there is no inventive step. We check all that, and then if there is all these problems, if there is any objection, we send it to the applicant. The applicant has to reply back within a period of time, say 6 months, and once it is done, if they make any sort of amendments or changes, then the patent can be granted. If it is not still, if the examiner and controller do not feel that it is correct, then they will call the applicant for a hearing under section 14. Again there will be a hearing. The applicant can raise all his doubts. The controller can tell them what can be done, and then it can go for a grant, right? So these are the basic timelines. So there are a few timelines that within which you have to file for the reply. Okay. Now let's look at design. So what is a design? A design is so design is very simple. So if you look at your pen, do you all have pens? Just take out your pens and show it to me like this. Yes. So if you see, all of your pens may be having a different shape, different size, different colors, right? Different names. Okay, so you can look at it from that angle, that suppose you have a Reynolds, you remember what a Reynolds look like. Suppose you have some other, what is the other pen? Link, right? So all of them have different shapes, different sizes, different colors, different aesthetic look, right? So that is what a design protects, the aesthetic look, the ornamental look. So there is no technical aspect involved in design, right? So if you look at this, the biscuits that are lying on the table, so even those biscuits can have a design registration, because both of them have different aesthetic value, right? So just look at this. So we have any aesthetic, ornamental or aesthetic aspect of an article. So it is feature of shape, configuration, anything can be done. So if you look at the first example, can you tell me? Can you just try to tell me what that can be? Yes? Yeah, I know it's a sari, but what is it? I mean, how do you link it to IPR? How do you link it to? Yes. So what is What is the industry? Textile industry, agreed. What else? So you have so many designers, right? International designers hai na? Like for example, right? So all those are all the designs that they create. A lot of them which they feel are very important and which they feel that are need to be registered are registered in our office. So Mr. Sabyasachi, do you know Mr. Sabyasachi? Yes. Which is the most famous product of Mr. Sabyasachi? One of the most famous products. Who designed the लहंगा? ठीक है, ऐसे लहंगा थोड़ी बोल के आप वो उसका क्या मीनिंग रहा? आप मुझे ना कुछ ऐसे बताइए ना, स्पेशली द गर्ल्स. आई एम श्योर यू मस्ट बी अवेयर ऑफ ऑल दिस. See, that is the whole fun of IPRs. It is all around you. You just need to look at it from that angle. Deepika Padukone's sari was wedding sari, right? Okay, who designed the Olympic the uniform of our athletes of our contingent? गूगल मत देखिए अभी. तरुण तहलानी है ना. So all these are very famous. They are all famous. They protect their designs because it's a very big industry. They have a lot of they not only money. It is also related to their own name, right? The brand, their image. So because of which they have to protect it. If you remember, there was one movie, Bunty and Bubbly. Do you remember that movie? I don't know, maybe तुम लोग बहुत छोटे होंगे, but there was this movie in which there was this issue of a design of the design being copied. So there was a fight between two designers who said that the lehenga of Miss Bunty, no Bubbly, Rani Mukherjee was copied from some other designer. So all this, you know, you have to read it from that angle because it's a very important thing. It goes into it goes to the courts, and the courts then decide on all these aspects. So you also need to have respect for the other person's IP. Okay. Then we have bags. So again we have the same aspect. Bags का बताइए कौन है? Who are the players in? हाँ, मुझे कुछ सुनाई दे रहा है. इतना साइंटिस्ट हो लेकिन ये तो ऐसे आना चाहिए. लुई विटॉन और गुची और सो यू हैव टू बैगेट, बाटा, है ना. So designs can be for anything, right? You can have it for toys. So you can have it for toys. You can have it for pens, as we discussed. You can have it for a clock. You can have it for pencils, right? You can have it for bottles, different shapes of bottles. You can have it for even biscuits, just as I told you. Because why is it so important? Can you tell? Because every design establishes a unique selling point of that particular product. Because you buy because you feel that you like the design, you aesthetically you like it, so it establishes a unique selling point of that particular product. So it can be also applied to a set. So for example, so you will never wear two different shoes, right? So you will have the same design for. And what is not a design? So something which is a part of the trademark, which is a property mark, which is an artistic work like painting and building. And there is a list of non-registrable designs which is there. Signs, emblems or flags of any country. They cannot be registered as design. Again, what is the criteria? So we have novelty and originality, we have prior publication, that is not acceptable, and the main aspect is it should be significantly distinguishable from the already registered design. Again, you can file it anywhere in India, and design registration is comparatively simpler. You just need to file for the form 1 along with the for images of the design in 3 different 2 sets of representation, and that's all. Right? So this is a specimen of a teapot, right? So helps the consumers to recognize any product and creates a unique selling point. Okay. Now we come to trademarks. So what is a trademark? It's any word, name, symbol or device. So can you give me examples of trademark? I'm sure you will be able to. Yes, trademarks. BMW, right? What is the trademark of BMW? Yes, I think the men will be able to shed some light on this. नहीं ऐसा नहीं है, मैं ऐसे कुछ gender discrimination नहीं कर रही हूँ, but just generally so that the men are also responsive. Yes, any one of you. अभी गूगल पे नहीं जाना, अभी नहीं अलाउड है, तो कुछ भी हो सकता है ना. मैकडोनल्ड्स है तो आप जयपुर के हाईवे पे जा रहे हो और आपको दूर से दिख गया, तो आपको पता है कि वहाँ पे मैकडोनल्ड्स आएगा, है ना. वैसे ही आप कोई और आप किसी शॉप में जाते हो और आपको दूर से दिखता है कि वो कोको कोला है और वो पेप्सी है ना, या थम्स अप है. क्यों? बिकॉज ऑफ देयर ट्रेडमार्क्स, है ना. मैं जब सवेरे उठती हूँ तो मैं सबसे पहले ब्रेड के ऊपर कौन सा बटर लगाना पसंद करती हूँ? अमूल. क्यों? क्योंकि वो छोटी सी लड़की है. द सॉन्ग इज़ वेरी कैची, utterly butterly delicious, Amul. Why? Because it establishes a loyalty, a link. Because I like it, I feel that no, that is good. And then what does it do to the product? Wherever I go and buy Amul butter, I expect that it will give me the same taste and the same क्वालिटी, है ना. क्यों? क्योंकि वो उस कंपनी का बना है, उस ब्रांड का है वो, और उसमें वही टेस्ट आएगा. वैसे ही अमूल का वाइट बटर भी है कि नहीं? पता है ना आपको, अमूल का वाइट बटर भी है. वाइट बटर का टेस्ट अलग रहेगा कंपेयर्ड टू द येलो बटर, राइट. सो व्हाट इज इट डूइंग? इट इज एस्टैब्लिशिंग अ customer loyalty base to the particular product, you know. So these are the different subject matter of trademarks. Like for example, I've told you. Can you tell me about sound marks? अभी एक कुछ हुआ है, हाँ? अरे मुझे कुछ सुनाई नहीं दे रहा है यार, जोर से बोलो. हैं? अभी I think 3-4 days back there was a news item, there was a news bite about this. Something about Arijit Singh. Okay, Amitabh Bachchan has protected his voice under trademarks, okay, because everyone keeps copying, है ना. आप सुनते हो, बहुत बार सुनते हो अमिताभ बच्चन का आवाज़, and because of his brand, because of that, a product is being sold. So he expects that if a product is being sold by using his voice, he should be given a royalty, right? So that is how it is linked. Get it? Okay, so what is a good trademark? It should have distinctiveness and it should not be deceptively similar. For example, do you know the news about this? Do you know the news about this? Very recently there was.
फाइल किया है कोई पानी की बोतल थी, स्पेलिंग गलत था, उसकी वजह से उसके शायद ब्रदर ने वो पानी पी लिया था, तो उन्होंने वो बोतल लेके गया और केस फाइल किया था कंपनी पे.
Yes, because there is a, this is called deceptive names. So whenever you buy something, if you're buying something, you should be very clear, you should be very sure what you're buying. Do not buy something which is deceptively similar, because what you are going to get, you are going to pay for 20 rupees, but what you are going to get is maybe the DDA water. Okay, so we have to be careful, right? And so when you look at products, you will find that there are some places where TM is mentioned and some places where R is mentioned. So this is the differentiation. Again, how can you protect it? Now there is a point that it is not essential that trademark has to be registered or has to be registered. But if you want to take any legal action against someone, then you need to have it registered in India, because it is a territorial right. Okay? So again, it's a very simple way of doing it. You just need to file the application along with the fee and your your symbol, your device or whatever, and then you can. Then you come to copyright. Copyright is a bundle of right, and it is an automatic right. So as soon as you write you write a story and you say that this is my story, and you put it in your computer, and after 20 years also you have a copyright over it. But if suppose someone steals it, then it is very difficult to establish. So people normally like to take a copyright over that particular things, especially in films and music, in all these aspects, because it is there is a lot of things at stake. And again, you look at creativity, you look at originality, and you look at fixation. These are the different subject matter of copyright. And you need to remember that computer programs in India are protected by copyright, not by patent, because it is a written code, and it is not, you do not get a product out of it, right? So it is protected under copyright. So you have two different types of rights here. You have economic rights and moral rights. Economic rights are when you are transferable rights. You may sell your story to someone else for can you give me an example? Yes. So you are selling your story to a filmmaker to produce a film, right? So you have an economic right. You can get an economic right out of it. Do you remember any sort of such? Three Idiots. Who was the author? Okay. What else? Who else? Yes. Milkha Singh. That is a biography, no? Harry Potter, right. So, along with the economic rights, you also have the moral rights, and under this, the author will always have the moral rights with him, and no one can use it in such a way that the name of the author is spoiled. Okay? The spirit of that, what he has written, has to be the same. So scope of economic rights, so you have reproduction right, distribution right, right to create derivative works, right of communication to public, right of public performance. Do you know which broadcaster has the right to broadcast your Olympic Games? Right. So is Sony allowed to do that? No. No. Why? Because Why? They come under the broadcast rights. So they buy these broadcast rights at a very big amount, and this is a very big thing. Like कुछ I think ICC World Cup कौन का राइट किसके पास था? हाँ, हॉटस्टार है ना. हॉटस्टार किसके साथ एसोसिएटेड है? हाँ, डिज्नी. बट डिज्नी इज एसोसिएटेड विथ व्हाट? स्टार स्पोर्ट्स है ना, बट नॉट विथ सोनी, राइट. आज के डेट में श्रीलंका इंडिया का मैच कहाँ आ रहा है? सोनी पे. सो यू कैन सी दैट these are broadcast rights and they are sold to the broadcaster. So term of protection, so it is different for different creatives. Like for example, if it is dramatic, artistic, musical or published works, and it is life of author, it is 60 years. Film, it's 60 years from the date of publication. Reproduction rights is 25 years and performance right is 50 years. Again, you have to file, and again it is form 14 has to be filed, and you can file it at the Copyright Office. Semiconductor integrated circuits layout design. So this is important for fast changing technologies such as electronic gadgets, computers. 10 years is the time period. And I'm sorry. And can you give me an example of such things? Where are chips used? In your mobiles, right? In your laptops. So do you know what the government has done regarding this? So this is your homework. Okay, tell me what the government has done regarding this. Okay? Now we'll come to geographical indications. Last है तो जल्दी खत्म कर दूंगी मैं. So geographical indications of goods are defined as that aspect of industrial property which refer to the geographical indication referring to a country or to a place situated therein as being the country or place of origin of that product. Like for example, I have given examples. So we have five different types of geographical indications. So one is agricultural goods, textiles, handicrafts, and I'm sure you are aware of all these, even though you may not be knowing that they are GIs. Do you know any GIs from your state? Yes. कौन सा मैंगो? मैंगो बोल के geographical indication है. बनारसी मैंगो, बनारसी आम. और कोई आम का नाम बताओ. बनारसी आम तो GI नहीं है. हाँ, रसगुल्ला. कहाँ का है रसगुल्ला? किसने बोला? कोलकाता का है कि उड़ीसा का है? अब वही फाइट चल रहा है कि उड़ीसा का है कि कोलकाता का है. So Kanjipuram silk is very famous. Banarasi sari is very famous, right? Sambalpuri saris are very famous. You have Darjeeling tea. You also have what other type of tea? Assam tea. Orissa ka tea. Okay, you also have the Makrana marble, which falls under the natural group of GIs, and you also have Ratlami, Save, all these which falls under the food and food products. These are some other examples like Katputlis of Rajasthan, Bagh prints of Madhya Pradesh, Bengal Patchitra, Cherial paintings, Bidri ware, Worli paintings. So anything that is there in a particular geographical origin, right? Only those are given a geographical origin. So you have Maghi Pan, you have Shahi Lychee of Bihar, you have Kurg orange, you have Kashmir saffron, and this is the examination. Some more examples. So you also have rice, different types of rice. And you have to remember that the last 5 examples of IPR where can be granted to a person, to an individual, but geographical indications are community rights. So one whole community is given the right to use that particular GI tag. And I think that's all. So yes, so you can all come as examiner of patents and design. So we'll have a short quiz. Can you tell me the different IPs in this single product? Tell me about the LED display. Yes? What is it? LED display? It can be protected as a patent, right? Body of laptop? Apple sign? User manual? Layout of IC? SICLD, right? Tell me about these. What is the first one? Second one? Huh? Copyright. Right. Third बताइए. सिर्फ डिजाइन, सिर्फ ट्रेडमार्क and SICLD and पेटेंट है ना, पेटेंट रहेगा ही ना. फोर्थ, फिफ्थ, design and trademark. Also something called trade secret, because this is not patented, it is protected as a trade secret. What protects the advanced disc brake for bike developed by inventors? हैं? ऐसे तो मत बोलो, फिर से पढ़ाऊंगी मैं पूरा फिर से. पेटेंट है ना, बिकॉज इन्वेंशन है वो, है ना. Which of these is a geographical indication? Yes. My state, my place. What does the trademark protect? मैंने जैसे ही बोला कि मैं पढ़ाऊंगी फिर से तो सब करेक्ट आंसर्स आने लगे. I don't even need to ask the question. If you write an original story, imagine a cricketer sets up his own company. What type of intellectual property can be used to show that the clothes are made by his company? Trademark and design. Whom am I referring to? Huh? Virat. What is the name of his company? If a company develops a new technology that improves its main product, what type of intellectual property? Yes. So technology is always patent. Right? Thank you so much.
So any questions, any clarifications? No.
They are so tired.
Really? Can we have one more lecture? All right. So I'm sure Tulsha Rao is very known for delivering complex subjects in a simple language. I hope all of you answer her questions. Yes, madam is always ready to give one more certificate. In addition to the certificate what IRA gives you, right? That certificate is from NEPAC, right? So that's the reason why a series of questions were asked by you. Okay, anyway. So I'm sure you are more knowledgeable now than when you arrived in the morning here. So that is utility of having one day program like this, very focused and a specific topic, too much of diversion into other areas. That is the power of having this kind of workshop. Right? Now all of you are more English now in terms of IT related issues, IT related terminologies, jargon. So I really thank Dr. Usha Rao for sparing her time. In fact, we wanted to have Dr. Usha Rao's lecture as an inaugural lecture because that would set the stage for all of you to understand this IPR related issues from other speakers. But unfortunately, this morning, Madam was so busy in some other inevitable engagement. Last night, I spoke to Madam. In fact, she wanted to cancel her lecture. But I was insisting that no, it cannot be like that. You have to come. We are ready to accommodate any time in the day. And she gave the slot 3:15 to 4:15. So you can imagine how busy Madam is. So you are privileged to listen to Madam. So Shipra was a little panicked last night. She called me. She never calls me after 9:30. She called me and apologized. I'm calling you. No, it's something serious. That's the reason you're calling me. Tell me what's the problem. So that Dr. Usha is not coming. So her tone was a little low. So no worries. I will talk to her. What exactly is the problem? But we need to understand the problem first. Then we can accordingly take a decision. So we understood and offered an alternative time. That is this afternoon. So instead of inaugural lecture, this is a closing lecture, right? So in any conference, inaugural lecture and closing lectures are the best ones. And the closing lecture is to be the even better one than the inaugural lecture, so that people carry some take-home message. So that is a role what Dr. Usha Rao played now. So thank you so much for coming here, addressing our students. And the series of 2 workshops what we conducted last month and this month, really rewarding. I'm very happy that 70 students in the last batch and around 40 this batch, around 105 students directly benefited from this workshop. So I'm sure at least a couple of you filing a patent from BSc, that is our success, if not all of you. That is too greedy, right? So
Let us be as greedy as possible.
let us be very practical also. I wish all of you definitely. So at least that's expectation from us. So with that, we'll close for today. Anything else, Chitra, you want to add on?
No, sir.
Come this way. So you too. So they are the main people. There is your deputy. That ran away. Okay. So what else you want to?
Some feedback over the mail, probably.
Now, before we wind up, let us listen to at least a couple of you just to give us some feedback so that we try to improve the next workshop if it is not really up to the mark. So I am not going to call anybody, but if anyone volunteers, I really appreciate. From this side one, that side one. Anybody please. Be free and give us a short feedback. Shall we call the Delhi University students? Yeah, please come this side. One of you. From IRA one, from DU one. Okay, that's a pair, right? Let's take first IRA. Anyone, please. Rangoli? I didn't want to call you, but you are not responding. Please come. So open feedback only. Nothing to hear about. You are going to tell what you like. Be ready, one of you. Come here. Rangoli is a PhD scholar here and doing experiments, research in plant pathology and plant virology in particular. So since she is from our division, I had the right to call her, right? So please, you can offer the feedback. What you learned this morning.
It was a very helpful session for all of us. I was not aware about anything about patent, what needed for application, please to start with the application of patent and all. So it was really helpful for us, and in future it may help me and
If I ask you, is there any way we can improve, what would be your solution?
improvement. Learn more about this practical, like how
That's a
to,
message for you.
how to start with the application process.
Probably you can conduct one more workshop on how to fill the application form for filing a patent.
At times we give the exercise for led to any invention as such, so that you can draft the claims. That really hampers the work.
I think she's here only. You're also going to be here for at least another 1 or 2 years. So probably, I think they are organizing a meeting on a regular basis. None of us are aware of. So they are conducting a series of online programs. Yeah, anybody, thank you so much. So I think you can make use of their expertise. Right in IRA we have the patent experts, right? So that's our strong point. We don't have to pay anything for that. It's a free service for all. So make use of their research and their expertise. If at all you have some patentable invention in your thesis or whatever IP,
Yes, any
IP related inventions or whatever, you can always approach them. Okay. We'll listen from another attendee from the university. So
Firstly, thank you for inviting us, and it was wonderful lecture. Actually, we don't know anything about the IPR and this all. We are MSc final year students, and for our future, if we are pursuing PhD, it will be a great opportunity for us how our work can be protected under the right, under the guidance of the government rights. But this is the great मतलब बहुत कुछ सीखने को मिला और मतलब और भी स्टूडेंट्स को आना था, but we have classes and our practicals, so we have managed to come. It was wonderful experience and it will be very beneficial for us. Thank you.
thank you so much.
Go back, you should try and organize for the others.
So you can invite Dr. Luksha.
No, no, no.
No, no, you have to go around.
I didn't mean that.
No, I really mean it.
No, but I didn't mean
See, I tell you, this area, this IPR related jargon, terminologies, many students are not aware.
Actually, we have
Very few. And even they do not know there is something patentable in their own thesis project. That's the worst part.
So that is the whole issue, because when I was doing my PhD,
Yeah.
even though I had a microorganism which was very good for bioremediation, I didn't know it. And since I didn't know, I didn't patent it because I had genetically modified it. But I couldn't patent it. And that is something which always is there at the back of my
Yeah.
mind.
So years back in 2005, I attended a IPR awareness program conducted by ASCII Bellogs in Hyderabad, Academic Staff College of India. So that's the first time. Of course, I know a little bit. Half knowledge is sometimes dangerous, you know. So I attended a formal meeting, 5 days program, only on IPR, beautifully conducted. I still recall a scientist from CCMB arrived as a invited speaker, and that lecture I will never forget. What he did, he brought a research paper on the screen, and he showed us how the research paper can be converted into a patent draft. Right on the research paper, he made all the corrections. So what word he should use, what we use as a technograph, and that word is not needed there because it is a techno-legal document. So he beautifully corrected that. End of the day, that research paper has become a patent draft. So that's the power of, you know, the person who, I still remember his name, Dr. Gauri San, is a microbiologist. That was the first time I got to know about, you know, how every research paper there is a potential commercializing that invention or whatever IP is there, number one. Number two, so seeking the IP protection and commercialization. These two are very, very important. So I would say for our science, a research paper can be converted into a technology. The technology can be protected through IP, whatever is fit there. And after that, it can be commercialized. So the last three we normally do. Now the ICAR has initiated the technology certificate, the process now. And now everybody is taking a technology out of the research paper, submitting the research paper and technology together for ICR for getting the certificate. That's now going on since last 1 year. That is the next step. So far we are happy with the papers. Now we are going one step again, converting the paper into a technology. Now I'm sure the technology what is coming out of the paper eventually will go to IP protection. So that is the next step. So with that, I thank all of you. And but before that, we would like to honor our speaker this afternoon. So you are going to do that, right? Okay. Okay. Thank you, Dr. Usha, for again. Evening wonderful for all the students. So that's not the end. We have some more to you. Some beautiful.
I would just like to add a few words. I mean, hats off to all the agricultural scientists. As the PM had mentioned in his speech, where he had met the agricultural economists, we are self-sufficient only because of the work of people, of scientists like Dr. Kumar. And I hope that all of you would also be part of this ecosystem. Yes, patenting and everything is fine, but products are also very important. Really hats off to all of you. And thank you once again for listening very patiently to me. And it was very tough. I could see a lot of, people were fighting literally. Students were fighting to sleep. But you managed. You managed. Thank you so much.
So I think we are closing this session today, workshop. So thank you all for showing interest and registering for this program, for attending this program here. So let us meet in another program very soon, in another time. So thank you one and all, and let us conclude the today's workshop. Thank you.
हाँ हो ही गया, ये लगा लेना, कट कर दूँ। लाइव कट कर देना।